into a little bit more detail about the solicitor-client relationship and what are some of the obligations that come with that.
Okay, a lawyer or anybody else can provide anybody with legal information, because that's not related to a specific fact situation. The answer isn't going to change depending on what the client's situation is.
Right.
And when giving legal information, a lawyer is not going to tell somebody what they should or shouldn't do, or what they can and can't will be likely to succeed at. It's just legal information. Once they step over that line into providing legal advice, then a solicitor-client relationship is formed. And there are basically three components to what that relationship looks like. The first is that it creates a fiduciary duty to the client on the lawyer's behalf. So basically, lawyers have an overarching duty to perform legal services that they undertake on a client's behalf to the standard of a competent lawyer. And that's words taken right out of the Law Society standards. What this means is that a client is entitled to expect your lawyer to have the ability and the capacity to deal with your legal matters, that lawyers have a fiduciary obligation to their clients and have to be honest and candid with the client and act in good faith to advance the client's best interest. So you've got to look after your client's best interest. And you do that once you're in a solicitor-client relationship. You don't have that if you've just provided legal information and there's no other relationship created. The other factor that comes in on a solicitor-client relationship, which is really to the benefit and advantage of the client, is the confidentiality requirements. So similar to the relationship between patients and doctors, a lawyer has a duty of confidentiality towards the lawyer's clients. As lawyers, we hold in strict confidence any information concerning the business or affairs of our client. And we will not divulge any client information unless we are specifically authorized by the client to do so, or unless the law requires us to do it. This means that we can have clients to engage in a fully honest and unreserved conversation and communications. And in turn, it allows us as lawyers to provide the most effective representation for our clients, knowing we have all the relevant facts. The duty of confidentiality continues even after the client's cases come to an end. So once you've told me something in the course of a solicitor-client relationship, 10 years down the road, I can't go and talk to somebody else about what we had discussed in your case 11 years ago, unless you specifically told me I can do that. So it's making sure those conversations remain private. Okay, in addition to the duty of confidentiality, it goes hand in hand with another concept called solicitor-client privilege. So what solicitor-client privilege means, and it only exists once that relationship has been formed, of a solicitor and client relationship, is that once you're in that relationship, any written or spoken communication between a client and the lawyer is privileged, and it cannot be disclosed in the course of litigation or otherwise. So the existence of that privilege gives clients further assurance that they can be truthful and honest in all communications with their lawyer. So basically, once you've told your lawyer something or you've given them something in writing, the lawyer cannot do anything with it unless the client specifically authorizes it. But that happens within the solicitor-client relationship. Okay, it doesn't happen if the lawyers just provided legal information. Okay, another important duty that lawyers have towards clients is the duty not to act or to continue to act for a client if there's a conflict of interest. So that happens when there's a substantial risk that the lawyer's representation of you as a client would be adversely affected by the lawyer's own interests or the lawyer's duties to other clients or third parties. So these can happen when a lawyer is asked to represent a client in a matter where the lawyer has a personal stake in the outcome, or where the lawyer is asked to do something unethical, such as lie to the client. You just can't do that. A conflict could also arise if a lawyer is asked to act against a former client in a matter. So like, let's say that now you come in to see me to negotiate a separation agreement, and we do the separation agreement and I close my file, and 2 years later, your partner comes to see me because he wants to take you to court to change the terms of that agreement. I can't act for that person because you and I have established that solicitor-client relationship. The duty to avoid the conflict of interest requires all of us as lawyers to refuse to act in these situations, because that means that we cannot fulfill our obligations to act in our client's best interests. And that's always the basic major concern. And that again is the whole importance of getting into that solicitor-client relationship and knowing exactly when it starts and then when it ends, because you know that you're protected as a client, and the lawyer knows exactly what they're required to do to protect the client. And that's the whole point of this solicitor-client relationship, is to protect the client and act in the client's best interests at all times.
Helena, a question. So this solicitor-client relationship seems to be a very formal relationship. So is it always signified by the signing of a retainer agreement?
It should be.
Okay.
The Law Society recommends that in all cases, once that you enter into a solicitor-client relationship with a client, it should be documented, because that way both parties are very, very clear about exactly the scope of what you're hiring the lawyer to do.
Mhm.
The lawyer knows when the clock starts to tick for when they can bill and what they can bill for. And the client in that retainer agreement then knows exactly, or should know, how much the lawyer is going to be billing them per hour, with an estimate of maybe what the total amount is that's going to be paid. So that whole thing should happen. And again, the reason there's such an emphasis on saying it should be formalized, it should be written down into a retainer agreement, is the traditional example that I've used in other videos that we've talked about before.
Mhm.
Is the lawyer that's probably had 3 or 4 martinis and has their next door neighbor come up to them at a cocktail party
Yeah.
and says, "So my wife and I are splitting. She wants part of my pension. Is she entitled to it? What should I be looking at to pay her out?" And the lawyer says something, and the neighbor goes, "Great," and runs off and goes to court, gets blown up completely in the argument that he's making, and says, "But I got advice from a lawyer. This is what my lawyer advised me to do." And back in the day, there were cases where, depending on how much specific fact information the lawyer got from somebody, even in a completely social, informal cocktail party environment, if they gave the advice to a person, knowing the person was going to act and rely on that information, they've created a solicitor-client relationship. So that's why now the Law Society is very, very clear, saying do not ever do anything to put yourself in a situation where a client thinks you're in a solicitor-client relationship, unless you actually are. And the best way to do that is document it with an agreement. It protects everybody. It's not something the lawyer is doing to scare the client. The retainer agreement is there to protect the client as well.
And it's also not the reason why your lawyer friends are always seem so unfriendly. At parties, when you ask them just a tiny little legal question and they run to the other side of the room.
Well, again, like it's just that's what you do in your day job. Why do you want to do it when you're at a party, right?
Right.
But
Right.
most lawyers, again, are very good about willing to provide legal information, because that's just something, if it helps people get started in the right direction and then they've got at least a starting point, then it's up to the person to decide if they actually do need or want to retain a lawyer. But that's always the starting point. But just don't ever think because a lawyer spouts off for 5 minutes on something because you asked them a question at a cocktail party, you can go and say, "Well, this lawyer told me to do this," because it shouldn't happen that way.
So I'm going to have a link for the YouTube viewers so that they can access the rules of professional conduct below.
Yes, the Law Society website is actually very, very good with information for clients.
Right,
So they've
yeah.
got a lot of very helpful information on saying what a solicitor-client relationship is, how do you get that done, what does a proper one look like, and what you
Right.
should expect from your lawyer. So yes, please put that link up there. It's great.
Okay, sounds good. Okay, so thank you so much, Helena, for clearing that up, and thanks everyone for watching. If you found this video helpful, don't forget to give us a thumbs up, and also don't forget to subscribe to our channel for more legal education videos. See you at the next video. Bye.
Thanks, Heather. Bye.
Bye.